This is Mary Todd Lincoln. President Lincoln said that you could fool all of the people some of the time, and some of the people all of the time. But he always said that you can never fool Professor Buzzkill, so don't even try. Let's join the good professor as he talks history, busts myths, and takes names. I'm getting a little hot and bothered just thinking about it.
In 1969, a 21-year-old Texas woman named Norma found herself sitting across a restaurant table from two young Dallas attorneys named Linda Coffey and Sarah Weddington. Norma was more than down on her luck. She'd been a ward of the state as a child. She was married and divorced by age 16 and hated by most of her family after coming out as a lesbian. She'd suffered for years from problems with drinking and drugs. And she'd had and lost two children already, the first to her mother and the second to a stranger's adoption. And now she was pregnant for a third time. Linda Coffey and Sarah Weddington, the lawyers, had recently begun advocating for women's reproductive rights in Texas, and they were looking for a plaintiff to help build a case to bring to trial. Now, at this time, abortion was only legal in the state of Texas for the purpose of saving the life of the mother. The lawyers Coffey and Weddington wanted to challenge this ban, but to do so, they needed a plaintiff and testimony from a willing Texas woman who was seeking an abortion. That's where Norma came in. Norma's full name was Norma Mccorvey, but her two lawyers quickly filed a class action suit based on her case, giving Norma a legal pseudonym in the process. That was Jane Roe. The case, the Roe versus Wade case, eventually made its way to the Supreme Court in 1970, and the decision reached there has made it one of the most famous cases in American legal history and in the history of women's rights. It's fought over in the public debate over the question of the legality of abortion to this very day. And because of some of the specifics in the ruling, it could very well be overturned within the next few years. The Roe v. Wade case is complicated, and the history behind it is complicated, very complicated. Norma Mccorvey's life story is also very complicated. And both the Roe case and Mccorvey's life are far too complex to, warrant the easy generalizations and certainties that I hear people employ all the time to talk about them. The specifics of the Supreme Court's Roe decision in 1973 are alone knotty and difficult to untie. But the case can also be used to help us understand why history is so much more complicated than most people think. History lacks those easy answers that people seem to want so much. It's not a treasure chest that can be thrown open Indiana Jones style, that, revealing one true answer and one solid set of facts. I need to make a disclaimer here, however. I'm not an expert on the history of abortion, on U.S. constitutional history, or the history of women's civil and reproductive rights. The basics of these stories are complex enough and can't be made plain in just one podcast episode, and so I encourage you to follow up with the readings and other resources I've listed in this episode's blog post on ProfessorBuzzkill.com. Born in small-town Louisiana, Norma was the daughter of a TV repairman and a violent alcoholic mother. When she was a little older, her family moved to Houston, where she briefly attended a Catholic boarding school. But after several run-ins with the law, which included robbing a gas station and running away with a friend to Oklahoma City, she was thrown out of that boarding school and put into the state school for girls in Gainesville in Texas. Now, according to her own autobiography, her time at the state school for girls was the happiest time of Norma's life. So much so that every time she was allowed to go home, she would do something bad just so she could be sent back. But back at home, the family's life was not much easier. Her father abandoned them when Norma was a young teenager, and this left the family in dire financial straits. So when, at age 15, Norma was released from the state school for girls for the final time, she was sent to live with her mother's cousin, male cousin, who allegedly raped her every night for 3 weeks. When her mother found out, that rapist convinced her mother that Norma was lying. And when she was 16, Norma got a job in a restaurant. It was there she met Woody Mccorvey, who was 7 years older than she was. They were married that year, and she was 16 and he was 23. She became pregnant, but before the baby was born, Norma left Woody and moved in with her mother after Woody had allegedly assaulted her. The baby was born in 1965, named Melissa, but the birth was not easy on Norma. And it was then that she developed a severe drinking and drug problem. Now, if that weren't complicated enough, it wasn't long after Melissa's birth that Norma came out to her mother as a lesbian. From the evidence available, Norma's story, own autobiography, and some of the state evidence about her case as a teenager, it appears that Norma's mother, anyway, thought that Norma was wild and out of control and an unfit mother. It also appears that she didn't believe Norma's lesbianism was genuine and sincere. It was just another way, she thought, to behave extremely badly and get more attention. So when Norma came home after a weekend of visiting friends, her mother replaced Melissa with a baby doll in Norma's arms while she slept off another one of her alleged nights of alcohol and drug excess. Now, this is a little bit unclear, but she hid the baby somehow, probably with relatives or friends, and reported to the police that Norma had abandoned Melissa. It's not clear, like I say, how all this happened, and the police do not seem to have acted on that aspect of the mother's report. In other words, they didn't arrest Norma for abandoning Melissa. But it is perfectly clear that Norma lived in a chaotic environment and that her excessive social life made it only more chaotic. Well, after tricking Norma into signing adoption papers, her mother obtained sole custody of Melissa and then threw Norma out of the house. The following year, Norma became pregnant again, and after the baby was born, gave it up for adoption on her own. If we move ahead to 1969, less than 2 years from where we were, Norma found herself pregnant for a third time and knew she couldn't go through the pain of childbirth and potentially losing another child through adoption. She couldn't claim that the pregnancy threatened her life, so she tried to get an illegal abortion. But the clinic that did that had been closed by the authorities. Now, her doctor suggested that she consult with an adoption lawyer who might know other lawyers working to overturn the Texas abortion ban. So in the hopes of obtaining a legal abortion eventually, and not really realizing or knowing how long court cases take, Norma became a plaintiff for those Dallas lawyers, Linda Coffey and Sarah Weddington, in their case. In 1970, they filed a lawsuit in the U.S. District Court for the Northern District of Texas on behalf of Mccorvey under the alias Jane Roe. The defendant was Dallas County District Attorney Henry Wade, the Wade in the case's famous name, Henry Wade. On June 17th, a 3-judge panel of the district court unanimously declared the Texas anti-abortion law unconstitutional, finding that it violated the right to privacy found in the U.S. Constitution's Ninth Amendment. That decision was appealed by the state of Texas all the way up to the U.S. Supreme Court. It took 3 years of trials to get it there. And of course, Norma's pregnancy, the reason she was seeking a legal abortion, couldn't be terminated. Norma's third child was born and immediately adopted. Now we have the audio of the opening oral arguments in the Supreme Court case of Roe versus Wade, the first pleading of it. And we're going to play a couple minutes of it for you, not to give you any real detailed content because it gets into legalese very, very quickly, but to sort of give you a flavor of the period and to hear the voices of some of the people involved. The first voice you're going to hear is the Supreme Court, the Chief Justice, Warren Burger, and then he asks the lead lawyer, Sarah Weddington, to open the case.
We'll hear arguments in number 18, Roe against Wade. Mrs. Weddington, you may proceed whenever you're ready.
Mr. Chief Justice, and may it please the Court. The instant case is a direct appeal from a decision of the United States District Court for the Northern District of Texas. The Court declared the Texas abortion law to be unconstitutional for two reasons. First, that the law was impermissibly vague, and second, that it violated a woman's right to determine to continue or terminate a pregnancy. Although the Court granted declaratory relief, the Court denied appellant's request for injunctive relief. The Texas law in question permits abortions to be performed only in instances where it is for the purpose of saving the life of the woman. The case originated with the filing of two separate complaints, the first being filed on behalf of Jane Roe, an unmarried pregnant girl, and the second being filed on behalf of Jane and Mary Doe, a married couple. Jane Roe, the pregnant woman, had gone to several Dallas physicians seeking an abortion, but had been refused care because of the Texas law. She filed suit on behalf of herself and all those women who have in the past, at that present time, or in the future, would seek termination of a pregnancy. In her affidavit, she did state some of the reasons that she desired an abortion at the time she sought one, but contrary to the contentions of appellee, she continued to desire the abortion, and it was not only at the time she sought the abortion that her desire was to terminate the pregnancy.
When this case was in the district court, the case of Vuitch against the United States had not been decided here.
That's correct.
Now do you think that has disposed of some of the questions raised now?
Your Honor, I do not. In the Vuitch decision, this court was working with a statute which provided that an abortion could be performed for reasons of health or life. Our Texas statute provides an abortion only where it is for the purpose of saving the life of the woman.
Hi, I'm Adrian, producer on Entertainment One's podcast network. Do you like what you hear? Check out The Reality Check, a podcast that debunks science myths you thought were true. Or if you want inspiring and honest stories that challenge the way you think about mental health, listen to So-Called Normal with Mark Hennick. You can listen to all of Entertainment One's podcasts on Apple Podcasts, Stitcher, or wherever you get your podcasts.
And on January 22nd, 1973, the Supreme Court issued a 7-2 decision in favor of Roe, striking down the Texas abortion ban as unconstitutional. Now, there are obviously many things that could be said about the proceedings of the case, but this isn't a legal podcast. But what's important to note here is that the court reasoned that outlawing abortions would infringe on a pregnant woman's right to privacy, and therefore her Ninth Amendment rights under the U.S. Constitution. And for these other reasons, having unwanted children may force upon the woman a distressful life and future, it said. It may bring about psychological harm. Caring for the child might tax the mother's health both physically and mentally. And there may be, quote, distress for all concerned associated with the unwanted child, unquote. But the court didn't necessarily rule that a woman's right to abort the fetus was absolute, meaning at any time during the pregnancy. The court adopted instead for a trimester model, that is, dividing a 9-month pregnancy into 3 relatively distinct periods. It gets even more complicated than that. This trimester model wasn't meant to decide when a fetus becomes a person, and in fact the court found that there was no indication that the Constitution's use of the word person as far as the right to life was meant to include fetuses. But here's what the majority opinion said. We need not resolve the difficult question of when life begins. When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary, at this point in the development of man's knowledge, is not in a position to speculate as to the answer, unquote. But in terms of enforcing the law, allowing women to seek abortions but not indiscriminately, the court again decided to use this trimester model. During the first trimester, the government could place no restriction on a woman's ability to choose an abortion other than minimal medical safeguards, like requiring it to be performed by a licensed physician. In the second trimester, the state could enact medical regulations on the procedure so long as they were reasonable and, quote, narrowly tailored to protecting the health of the mother. And the third trimester was when a fetus was generally considered viable, and the court said that from there on, the state had an interest in protecting prenatal life and could prohibit abortions, except when the mother's life or health were at risk. In the minds of many people, this is where the story ends. The Roe v. Wade case was won, and abortion became legal. But the reality is much more, and here's that word again, complicated. Just consider the trimester model. Even within the court's definition of the second and third trimester, there was room for argument over the meaning of the language in the decision. Other aspects of the Roe v. Wade language, putting that in quotes, led to other major legal challenges to the detail of abortion laws in various states. Some states were able to enact restrictions on what type of doctor was allowed to perform abortions. Some states were able to ignore or not adequately protect a woman's state of mental health and the effect a birth might have on her continued mental health when considering whether an abortion was legal in the third trimester. By my calculation, there have been at least 4 major Supreme Court cases dealing with individual state restrictions on abortion since Roe v. Wade. And of course, as I keep saying also, it'd be impossible to go through each of them in a single podcast episode. And this is, again, why I'm explaining why this is so complicated. Now, each time, the right to an abortion was upheld, but it seems to me for different legal reasons. Now, add to that the fact that at least one of the rulings, 1992's Planned Parenthood versus Casey, was a plurality decision, putting that in quotes, rather than a majority decision, adds a whole new layer of complexity. That means state legislatures can pick away at various abortion provisions in an effort, perhaps, to wait until the philosophical/political composition of the Supreme Court changes as justices retire and are replaced by new justices. Almost as complex was Norma Mccorvey's life in the 1980s and 1990s. She wrote a book entitled I Am Roe, and worked in abortion clinics until 1995. That year, she became an evangelical Christian, quit her job at a women's health clinic, and joined the anti-abortion group Operation Rescue. She became a Catholic in 1998 and continued to campaign very publicly for anti-abortion / right-to-life organizations well into the early years of the 21st century. Throughout this later part of her life, she claimed that she had been a pawn of those two young and ambitious lawyers, Linda Coffey and Sarah Weddington, who, at least in Norma's 1990s version of her own story, were just looking for a plaintiff with whom they could challenge Texas's abortion laws by any means necessary. And she died relatively recently in 2017 at the age of 69 from heart failure. Roe v. Wade, like all of history, shows us that no stories are simple, and when we try to use simple stories to defend our arguments, we just end up with simplistic arguments. And simplistic arguments all too often lead to short-term solutions at best and damaging controversies at worst. If our understanding of history is nuanced, the future we create can be nuanced as well. And a nuanced future is more realistic. It's more grown up in the adult sense of the word and will work better for a wider variety of people. I encourage you to look more deeply into the history of abortion and reproductive rights, as well as the history of the Roe case and the legal history of the abortion question in the United States. As I mentioned at the beginning of this show, I'm not an expert on these things. In many ways, I came to the research, the preparation, and the writing of this episode from a very privileged position. I've never had to struggle, even remotely in life, like Norma Mccorvey had to. And I've never had to deal with the extremely weighty questions placed before the Supreme Court in the early 1970s. So please follow up with the resources I've listed at the end of the ProfessorBuzzkill.com blog post for this episode. And finally, I'm quite happy to admit to the fact that this is only the second best podcast episode on the history of Roe v. Wade to come out this month. A couple of weeks ago, the wonderful history show Backstory released their episode about the history of the case and tied it most carefully and sensitively to the history of women's health and reproductive rights in the United States from the 1960s to the 1990s. In particular, their discussion of the centrality of Ms. Magazine to the increased social awakening about abortion in that period, as well as their explanation of how these issues fit into the broader social history of those years, is not to be missed. Please go to backstoryradio.org and listen to the episode The Many Lives of Roe v. Wade by Professors Joanne Freeman and Nathan Conley. Anytime we can be second best behind Backstory, we're doing pretty well. Please visit our website and email comments and suggestions about our show to info@ProfessorBuzzkill.com. Although I say we get tons of email, that's just show business promotional BS. We don't hear from you nearly enough. So write in, and we'll talk to you next week.